SJC-12769, Kevin Richardson, second, v. the UPS Store, Inc., and another.
And now I invite Mr. Brown on behalf of Kevin Richardson to speak.
Justices of the Massachusetts Supreme Court. MGL Chapter 262, regulating the fees of certain officers, is and has always been a consumer protection statute, implementing the unambiguous directive of the Massachusetts Constitution prohibiting the use of public offices for private profit. To this end, the legislature has always strictly limited the fees that public officers can charge in the execution of their public duties, and as those duties have evolved over time, the legislature, the executive branch, and the courts have all unambiguously applied fee limitations to every official act by a public officer and have in no instance countenanced the use of public office for profiteering in the manner advanced by defendants today. For the defendants to be right in their novel interpretation of Chapter 262, everyone else who has looked at the statute from the legislature to the executive branch to the courts thus far has to be wrong. That noting a notarial attestation noting the witnessing of an event is only applicable to the protest of commercial paper is an idea posited for the first time as a theory in this case and not supported by any authority, secondary or otherwise. The legislature's 2016 amendments to Chapter 222 directly recodified fee limitations in an act entitled An Act Regulating Notary Publics to Protect Consumers, and in doing so ratified both the prevailing Section 41 prohibition against charging more than $1.25 for any notarization and the governor's power to enforce the notary fee limit at the prescribed $1.25. Every court to touch on the subject thus far has recognized both the power of the governor to regulate notaries and the explicit fee limitation set by Section 41. So the Superior Court has aptly stated it is contrary to Massachusetts law and public policy for a private entity to aggregate the services of notaries public or any public officials who exist to provide a public good and to sell those services as a commercial good. In this context, Section 41 can be plainly and unambiguously read. The whole cost of noting, including the cost of notices and recording, shall in no case exceed $1.25. No case means simply in no case, and not merely in no case involving a protest. Defendants' requested interpretation is a strained one and requires the artificial insertion of words that do not exist in the statute and an inexplicable assertion of legislative intention to allow the use of public office for private profiteering. If the plain meaning of Section 41 is not clear enough for defendants, the statute sets a further express fee limitation through Section 43, which limits notary fees to those fees set for justices of the peace for like services. Fees for acknowledgments of deeds is set at 25 cents, and the legislature has clearly equated the acknowledgment of deeds with the acknowledgment of other instruments. I invite questions, Your Honors.
Thank you. Justice Link.
Yes, I was wondering what you thought of the amicus brief.
I thought it was extremely well done, and it set out the history quite accurately, that the fees of public offices have always been limited, and that's always been the intent of the statute. And no instance has the Commonwealth ever intended to allow public officials to charge whatever they want for their public services. That would be to the extreme detriment of the public that they serve.
In other words, you adopt the historical analysis of the amicus brief?
Absolutely do.
All right, thank you.
Justice Graziano.
Just a question about the executive order by Governor Romney. I think that, so to speak, died on the vine, and there was a reference in the briefing to the Chapter 289 of the Act 2016 that rescinded it. I take it that rescinded the executive order, and there was no further legislative pronouncement on this issue?
Well, the legislature, they rescinded the order because they explicitly gave the governor the statutory authority, recognized his statutory authority to regulate and set fees for notary publics. That's in, I believe, Section 16 of the new Chapter 222.
Okay. That was the only question I have. Thank you very much.
Justice Louis.
Yes, thank you. Mr. Brown, You're not going to be surprised with my questions, which involve statutory analysis. Section 41 at the beginning of the statute, it lists the events of notarizing that the fee applies to, and it includes the cost of protest, the cost of noting, recording, and notices. And then you go to Chapter 222, Section 1, which defines acts for a notary, and it refers to all acts of a notary public, including presumably witnessing a signature. So why isn't the analysis correct that witnessing a signature would fall within the definition for notary public under 222 Section 1, and Section 41 is limited to the list, protests, cost of noting, for example?
Because noting, because the word in no case, if the legislature wanted to, noting, and both sides admit that noting is merely an attestation. It's the witnessing of an event, and the notary makes his minute that he's witnessed an event, and it becomes an official witness of an event that has import in the courts. So the legislature could have easily said, in no act of protest, in no case of protest, shall the cost of noting be greater than $1.25. That's not what it says. It says, in no case.
But it's referring back to the beginning of the statute. After, as follows, it lists the universe of events to which it presumably applies.
I'm not sure I understand the question, Jeff.
Well, for the protest of a bill of exchange, order, draft, or check for non-acceptance or non-payment or promissory note. I won't keep on going, but it lists all the events to which Section 41 applies. And there's more to act of a notary public than is listed there. And you have the definition of that in Chapter 222. So the question is whether or not that last phrase, in no case, is referring to the list of events, Section 41.
No, the answer to that is no. That in no case means in no case that involves an attestation. And I think it's fair to say no case simply means no case, and all the world has interpreted in no case that noting as to apply to all acts of attestation, from the governor to the legislature when they ratified it. And you can see that when they exempted absentee ballots from the limitations set forth in Chapter 41, which the defendants only explain away as having the legislature misunderstood their own statute. So it doesn't make any sense from the history of this statute and the way the legislature has treated it and the way the governor is treated and the way the courts are treated. And even in Reba, the case that I cited, I quoted Justice McLeod, the entire Real Estate Bar Association stipulated, which is the most prodigious accumulation of notaries, they all accepted that limitation on noting applied to all attestations. And Justice, even if you don't get there through that definition of noting, when you go to Section 43 for services, acknowledgments, acknowledgement of deeds and other instruments, that's limited to 25 cents.
Okay, thank you.
Justice Bud.
Hi, good morning. Let me ask you about your reading the word noting as all acts of a notary public. Can you tell me what that is based on?
It's based on the commonly accepted interpretation that's evidenced by the legislature and the governor and the court so far, and also the plain dictionary meaning of noting, to make a note, and also from the case law that both the defendants and I have cited to, that noting is an attestation. Noting, a protest is completely different from noting. Noting is merely the official witnessing.
Sorry, just a second, because what I'm trying to do is figure out, just trying to figure out this section here. And it does talk about noting earlier on in the section, right? It says, for noting the non-acceptance or non-payment of a bill of exchange. And it goes back to, that's referring back to protesting negotiable instruments, right? Am I right about that? Yes. For it has, the first section talks about recording notices and actually drawing up the protest and all the fee limitations. So it's for commercial paper worth more than $500, you have a limitation on actually drawing the document that says, "Hey, we protest this dishonor," and that's $1. Right, and so I'm focusing on the portion of the section that talks about noting the non-acceptance or non-payment of a negotiable instrument, and that has a particular meaning. Is that correct? Yes. Noting that particular document is specifically limited. The fee is specifically limited to, I believe, 75 cents. Yes, and then, so I'm trying to figure out why we should assume that when noting is mentioned again further down in the same section, why we should assume that they're talking about any type of notarization when the first time they mention it, they're talking about a particular type of noting, or noting is used sort of as a term of art. Why shouldn't we assume that it's being used as a term of art the second time? Because of the words "in no case." So, in no case has been taken by the court so far, and by the legislature and the the executive branch, to mean applying to every case where there is a noting of a document of any kind. So any type, that has been fairly interpreted as being replying to the attestation of any type of document. And there's nothing to indicate to the contrary, and there's a tremendous wealth of historical evidence to support that interpretation. And you show me, because I understand, that it's supposed to be a consumer statute, and you're supposed to make sure that you're regulating the amounts charged. But I'm just trying to figure out exactly why we should say that noting in this section it engulfs everything. And I understand that other entities have interpreted it that way, but can you point to anywhere where the SJC has? Nowhere. Well, this is the first time up to the SJC, and I've already listed the lower court cases. Well, there was one instance where Justice Liakos, in a dissenting opinion in the Quinn case, he referred to the fees being limited by Section 41. But that wasn't the issue in that case, was it? It was not, but it just goes to show, it's certainly clear evidence that the bulk of the world, including justices in the Supreme Court, interpreted that noting as meaning exactly what we are saying that it means. And since really this discussion is we're trying to define the intent of the legislature when they passed this statute, and the only way to define that is really to look at what was commonly the meaning of that word was commonly given. And all you can look is to the general population, the courts, the governor's office, and the legislature itself. And of course, there's always the plain dictionary meaning of noting. Well, but I guess I'm wondering whether there is not a difference between noting and the term notarial act, which I know is used elsewhere in the statutes as what you want noting to mean.
Well, notarial act is broader than noting.
Oh, okay. Tell me about the difference there.
Well, for example, notaries can draw up a protest. Now, a protest, that's a notarial act, but that's different from noting. In that case, I'm sorry, Your Honor?
You said earlier that noting is just making a mark?
Noting is the attestation. That is the official attestation of the notary, where he says, this is what happened on this day, and I so declare it, and signs his signature and puts the date it happened. That gives his official witness in primature that event actually happened. But for example, the protest is a large document where it explains that there was this note, it was presented to the debtor dishonored it, and the holder of the note protests that dishonor. And that's all, and it also informs all the parties that they're going to be held liable on the note, and that had important significance for proceeding with a case to enforce that note back in those days. So that is a different type of document. So notaries do more than just attestations.
Okay, thank you.
No. Justice Cipher. That's I will. I just also want to say that I found that both briefs very interesting, and who would think that this would be so fascinating? Also, that you actually answered one of my questions already when you answered Judge Budd. I just want to make sure I've got it right. You're saying that if we adopt your approach, we'll be consistent with the majority of the other states as well as the Supreme Court?
Consistent with the, well, when you say my approach, I'm not sure what you're referring to, Justice.
Your definition of noting.
I don't, I haven't examined every other state's definition of, but I think it was commonly accepted in the case, the ancient cases cited by both sides that describe noting as an attestation or witnessing of event. That's accurate.
And you say one of those is the Supreme Court case?
I believe it was a New York case. Allen, I'm not sure. Allen was a New York Supreme Court case. I think we both, they cited to it, and it has a description of what noting is as being the attestation of the
So there's no United States Supreme Court case. There's no United States Supreme Court case.
I don't believe so.
Okay, thank you.
Justice Kafker.
So I've got a series of questions about, so let me start with the settled expectations. I have a vague recollection that when Governor Romney announced this executive order, there was a giant howling out there. Was there a change when he did this? I read your brief, it sounds like it was settled, that Romney was just doing what had been done in the past. I remember a real reaction to this. Is that correct, or am I misremembering?
I don't remember a real reaction. I mean, as far as I know, in the practice, from everything that has been looked at in the practice of the real estate bar to the practice of all notaries generally, they have accepted the limitation of $1.25 as being the limitation on their fees.
Was before Romney's executive order, was that what everyone was charging out there?
I believe so, yes, Your Honor. I can only speak from my personal experience as a notary, and that has always been my experience as a notary, that the limitation of $1.25. It's been around since I've been practicing law. That's been the accepted limitation, but it wasn't invented out of whole cloth. And I remind the justices that every notary to become a notary takes an oath, and for the period described in my complaint, all the notaries had to take sign an oath that they would not charge more than that fee limitation, and that they would abide by.
They say they take an oath that they shall not charge for any of their services more than what's in Section 41, or that they shall comply with their statutory requirements?
Both, Your Honor, because they, during the period of my complaint, they took an oath to abide by the governor's order specifically, which sets forth that you can't charge more than the fee limit set in Section 41. And that's an exhibit to my addend to the reply brief.
So we've got notarial acts or protests. Are there other notarial acts besides protesting?
There are many. Protesting is one notarial act. There's acknowledgments. It's really, it really does involve all acknowledgments. I mean, these terms in practice really refer to the act of always kind of refer to the act of a notary providing an official witnessing of an event. That's, chiefly what the notary does. So you can go before a notary.
I'm confused though. So is there a third category of things they do, acknowledgments that are separate from noting and protesting, or is acknowledgement the same thing as noting?
You see the words attestation and acknowledgement. They're all used relatively interchangeably because they're all fundamentally the same thing. Then came before me so-and-so and did this on this date and time, and I witnessed it. And that's what a notary does. And the notary is an official witness that's given, special credibility in the courts.
So that I just want to make sure, you say all noting, which I take it to mean all acknowledgments, everything but protests are $125. And protests are $2. That's set out in a different stat, I take, right?
Yes, well, protest, they set the limit for all of the aspects of protest, including the noting, at $2 if the commercial paper was more than $500, and I think at $1.50 if the commercial paper was worth less than $500.
And so what statute is that in? Where does the protest dollar amount appear?
That's in Section 41. The first part, up until we get to the part in no case, the first part is talking chiefly about commercial paper and the disarmament of commercial paper. There was this whole process, in the 19th century that a creditor had to go through in order to enforce that type of instrument against the debtor. And the notary ended up playing an important part because they were an official witness to these events. You had to present the note.
But then I get confused about what that means. What last sentence, including recording those, shall in no case exceed $1.25. It's obviously, it sounds like in no case except the ones described above, or because you just said that $2 is allowed for noting in certain types of commercial paper, right?
Well, the $1.25 limitation on noting is just for noting. Whenever, you take it on its face. Whenever a notary does a noting, they can't charge more than $1.25. Period. Except above, when they note a protest of commercial paper, they can charge 75 cents, but no event for anything can they charge more than $1.25. So period. So
I'm confused because you said they can do $2 for something, right?
No, they can do $2 as an aggregate limitation when they're actually drafting a protest, which is one document. Then they have to do an attestation on the protest that they officially witnessed it. Then 3, they record that protest. And 4, they have to give notices. Back then, once you wrote up the protest, you had to send it off to the debtor, and I'm not sure who else had to get notice of it, but you had to give all the parties notice of that protest. So there was a whole process involved, both a recording, a giving of notice, the drawing of the protest, and the noting of the protest. Those are 4 things. And they set a fee limit for all those things at $2.
And when they draft a protest, that's more than just, stamping the thing. They've got to do something more significant. Is that right?
Yes, you have to draft the whole document, and you have to describe the event, and then you have to advise everybody they're going to be held liable for the disarmament.
Okay, can I ask one last thing? You rely on the Secretary of State. I was just reading, according there, as a notary, you are a public servant and should be excessive charges could result in complaints to the Governor's Council. I'm just looking at this. According to the fee statute, notaries may charge no more than $1.25 for noting and recording a document, no more than $2 for protesting commercial paper. As a notary, you are a public servant and should be able to perform a public service at a reasonable cost. Why would they add that if everything's so defined? Why did they put that in there?
Because it's been determined by the governor's office, and so by the executive branch and by the legislature. I'm asserting that $1.25 was the reasonable cost. Look, just because the Secretary of State used the words reasonable cost in that instance, it doesn't vitiate all the very express fee limitations that are set forth in Chapter 262, including, hey, nobody's contesting that you can charge more than 25 cents for the acknowledgement of a deed, for example. That's very precisely laid out in Section 262. And then in another section, the legislature gives the power to notaries to take acknowledgement of deeds and other instruments, which is it's fair to say that the legislature equates the acknowledgement of deeds with the acknowledgement of other instruments. And in fact, in practice, it's the same. Then personally appeared before me so-and-so would acknowledge the foregoing to be his free act and deed. That's what it always says. The fee is really limited for those instances, the vast majority, to 25 cents. But it has been interpreted over time as the $1.25. If you're within that, that's the catch-all outer limit.
Thank you. That's all I've got.
This is Chief Justice Gantz. I want to turn you to Chapter 222, Section 19. It says a notary public shall perform a notarial act for any person requesting such act who tenders the fee provided for in Section 41 of Chapter 262 or any other general or special law or executive order. And then it says, unless, of course, we have reason to believe that the notary act is unlawful or whatever else. Is it your view that essentially, regardless of even if your brother is right as to what was meant in Section 41, that it may have been limited to noting, that this expands its scope to include all notarial acts?
Yes, absolutely.
Does this also mean that the governor, by executive order, could increase the $1.25? Does this give the governor the legislative authority to increase?
Well, it's specifically mentioned. Well, we're talking about the new statute that was passed in 2016,
right,
Your Honor. Yeah. So yes, the statute specifically gives the governor the power to set fee limits.
So if you're obligated to perform a notarial act, if somebody gives you the $1.25, then you're effectively saying that the legislature, regardless of what they did in 1830, in 2016 have essentially said Section 41 is to be the price for all notarial acts. Is that what you're arguing?
I believe so, yes, Your Honor. The new statute is such.
Was there any, I don't know the history of this. Notary publics are a substantial group with considerable lobbying power. Is there any legislative history with regard to 222, Section 19, or the entire set of statutes that were passed as part of the acts of 2016, which would shed light on this?
No, Your Honor. The new chapter 222 really it codified the Executive Order 455 because everything that was in 455 was essentially implemented. If you look at 455 and you look at the new statute, it implemented Chapter 4, the Executive Order 455. So it's the new Chapter 222 is more expansive and more precise, actually.
And that's the same statute which then made it a crime.
I'm sorry, Your Honor?
That's the same statute which made it a crime
Yes, it is now a crime to violate the terms of the notary statute. It was not before.
It's only a violation of this chapter, so it's a violation of Chapter 222, not necessarily a violation of 262, except to the extent that it's incorporated in 222, correct?
Yes, I agree, Your Honor, exactly.
And no, the $1.25 was established, what, 1830?
Actually, the catch-all was the original statute did not have the catch-all, and then the wording was changed. It was first passed in 1836 with respect to protests, and then so all of protesting was actually covered, and all the costs of protesting were actually covered. And that's an important point. The legislature decided to go back and add a catch-all in 1839. And so why would they do that if they weren't meaning to catch noting of any document? They had already covered all the various costs of protests with extreme specificity, from notices to recording to the noting to the overall charge for those pieces of paper over 500 or under 500. So they go back in 1835 and add this catch-all, and they also add the mandatory language shall, in no instance shall. So it was much more sweeping. And so the particularity with which that was inserted 3 years after the original statute also suggests that that the legislature meant that statement to have broad import.
Now, in about 99.9% of statutes which set a particular dollar figure before the Civil War, we generally cannot even imagine that dollar figure would be governing today. Why should this case be the extraordinary exception?
Well, Your Honor, it just shows how important the legislature has revisited this statute. I've cited it maybe 8, 9 times since the 19th century, and they've purposely chosen never to raise those fees. And not only the legislature, and including in this revisiting of the statute in 2016. So the legislature and the governor's office, every branch of government, the courts as well up till today, have really emphasized the importance of keeping these services cheap, because these services are often important to access to legal proceedings, and they don't want the most disadvantaged portion of the population to go without these important services. They might be deprived of due process. To some people, $10 doesn't make a difference, or the $8.75 differential, but for other people, it does make a difference. And I think that's what this is all aimed at.
All right. I have no further questions. Any other justice have any further questions of Mr. Brown?
Just one. This is Justice Budd. I noticed that your brother mentions in the brief that noting is used in a particular way here because it's about making sure the date on the protest is right so that they can go forward with the protest and all of that. And he cites several different sources for that particular meaning of protest. And I was wondering if you agree with that meaning, but you just are saying that it's different in the last sentence of Section 41, or you don't agree with that meaning at all?
I disagree that noting in this instance is limited to the application of noting in this is limited to noting protests only. Their argument is that noting only refers to the protest of commercial paper, and that this court is to ignore the words "in no case" or insert the words it means in no case of protesting commercial paper. I do agree in those cases that they cite to. I do agree that with the definition of noting as being an attestation, but there is nothing in those cases that says that attestation, a notary's attestation or noting, is only used in an instance of protesting commercial paper. That's a very, very important distinction. Noting is attestation. That is the general meaning, and those cases say so. There is no case that says, the only type of document that is noted by a notary is the protest of commercial paper. That's where we disagree.
Okay, thanks.
Any further questions? Mr. Brown, thank you. And now we'll hear from
Thank you, Justice.
Thank you, Mr. Chief Justice, and may it please the Court. I'm Joseph Palmore here on behalf of the UPS Store, Inc. This is a statutory construction case, so I'd like to make 4 points about the relevant statute.
Before you do that, I hear some more crackling. If there's anybody who's on speaker, can you take it off speaker, put it on mute so that we can hear Mr. Palmore better? And that may be a little bit better. I'm sorry. You had 4 points, Mr. Palmore.
Yes. It's a statutory construction case, so I'd like to make 4 points about the relevant statute through rules of statutory interpretation. These points show that, contrary to Mr. Richardson's argument, Massachusetts law does not cap the fees for all notarial acts at $1.25. At the heart of this case is Section 41, and as Justices Lowy and Budd's questions reflected, that provision provides a detailed fee schedule for notary services related to the protest of a dishonored negotiable instrument, and only for those services. The phrase at the end on which my brother relies, the whole cost of noting, including recording and notices, is a shorthand reference to the phrase that appears earlier in the very same sentence, noting the non-acceptance or non-payment of a bill of exchange or other negotiable instrument. That is consistent with the numerous 19th century cases and secondary sources we cite in our brief. Noting in Section 41 does not mean all notarial acts. In fact, notarial act is a separately defined term under Massachusetts law, and it is broader. Second, Section 43 does not apply here. That provision and its references to like services provides that when public officer A provides the very same service as public officer B, public officer A is subject to the fee cap for that service, even if the relevant fee cap statute is expressly addressed only to public officer B. In any event, even if Section 43 incorporates a similarity standard, it would not be satisfied here. The specialized function of noting a dishonored negotiable instrument is not similar to the simple act of witnessing a signature. Third, the 2017 notary law did not amend Section 41 or 43 to expand their scope, nor did it reenact them. So this case turns exclusively on the long-standing meaning of those pre-existing statutes. Even if the 2017 legislature or Governor Romney before it made an unexpressed assumption about the scope of Section 41, that couldn't alter its meaning. Statutes change through amendment, not the subjective thoughts of elected officials. Fourth and finally, the rule of law and bedrock fair notice principles compel the same result. For the reasons I just gave, the traditional tools of statutory construction yield but one answer here. But even if there is any ambiguity on the scope of these statutes, the fact that they are criminally enforceable means that ambiguity must be resolved to narrow, not expand. Mr. Chief Justice, I welcome the Court's questions.
Okay. We'll turn to Justice Lang.
I'm going to ask you the same question I asked your brother, which is, what do you think of the amicus brief's history? Now listen to us.
It's an interesting historical treatment of notary laws during the colonial era. I don't think it's of any particular relevance to this case. The amicus cites no evidence that the legislature in the 1830s meant to codify or incorporate those colonial statutes. And if anything, I think they cut the other way, because what amicus argues was that the colonial statutes prescribed fees for all quote-unquote writings. the legislature in the 1830s did not use that term. Instead, it adopted a provision related to the protest of negotiable instruments and the noting of negotiable instruments, which is, in this context, nothing more than a preliminary step in protest. So I think the amicus brief is interesting as a piece of legal history, but it's not of any particular relevance here.
You don't think it's wrong in any respect, though?
I don't. Except perhaps irrelevant in our favor in that it shows that there was perhaps a broader statute that had been used earlier that regulated the fees for all writings. The legislature chose not to adopt that and instead adopted this targeted provision. So to the extent that the amicus brief is relevant, I think it supports our position. Okay, thank you.
Justice Gaziano.
I have no questions. Thank you.
Justice Lowy.
Yes. Tell me, now that this has criminal implications, how does the rule of lenity come into this analysis?
Well, I think it comes in as a backstop, Justice. I don't think you need it here because I think that for the reasons that we go over in the brief and that I spoke about briefly before, the statute is quite clear that it doesn't extend to all notarial acts. In this context, it applies only to noting commercial paper in the context of a protest. But to the extent that there is any ambiguity on that question, the rule of lenity and basic fair notice principles would require it to be construed against its application because the legislature has now attached criminal penalties to the statute. And even though this is a civil case, the statute can mean only one thing, and this court has explained in the Doe case that we cite in our brief that the rule of lenity applies even in a civil context when you're dealing with a rule regulating primary conduct that is enforceable both civilly and criminally.
And what input is it that the governor and perhaps the Secretary of State have a different view than you?
I don't think it's of any impulse to the extent that they do, and I don't really think that they do, or at least if they did, it wasn't clearly expressed. I think the executive order from Governor Romney was quite explicit. It said right up top that it did not amend or alter pre-existing law. It took Section 41 as it existed on the statute books at that time. The 1996 guidelines, which I think Your Honor is referring to, the Secretary of the Commonwealth guidelines, they actually, again, are supportive of our position for the reasons that Justice Kafka mentioned. They simply state Section 41's fee caps for protest and noting without elaborating on what those terms mean. But then they go on to admonish notaries to charge only reasonable fees. That reasonableness standard would be unnecessary if all notarial acts were already fee capped at $1.25, as my brother argues.
Okay, thank you.
Justice Budd.
What are we to make of the fact that the title of the section is Notaries Public, Enumeration of Fees, and then Section 41 says the fees of Notaries Public shall be as follows. And according to your interpretation of this, it only talks about protesting negotiable instruments, which, do we even do this anymore? I mean, is this even a thing?
It is for foreign negotiable instruments, Justice.
Okay. But why?
And these,
yeah.
So, in the 19th century, these were the principal acts of notary publics, and we quote the opinion of the justices in our brief for that proposition. So at the time this statute was adopted, these were very important acts that a notary provided to the public, and it stands to reason that that's where the legislature would have targeted its price regulation. But again, the title that saying that if this is fees for notary publics or the fees of notary publics shall be as follows doesn't tell you anything unless you read on and you see what the enumeration of the fees is. And I would point out that the same analysis applies to Section 16 and 19 of the 2017 notary statute that my brother said might have changed or made the $1.25 fee generally applicable. That's not correct. All those statutes provide is that the fee caps, quote, provided in Section 41 apply to the notarial acts enumerated in Section 41. And Section 41, of course, includes a detailed schedule of fees for different services related to negotiable instruments, and you have to know which service you are talking about to see which fee cap applies. And it wouldn't make sense to say that the fee caps in Section 41 apply to all notarial acts, given that 41 has, as I count them up, 6 different fee caps. You can imagine an analogous situation as the statute said, a consumer shall not purchase a good without paying the sales tax provided for in the tax code. That would not make all goods subject to sales tax. You still have to go to the tax code to determine which goods were taxable and which goods were exempt. And so too here, the provisions of the Notary Act 16A and 19 require compliance with the fee schedule in Section 41, but they don't change that fee schedule. You still have to look at Section 41 to determine what is covered and what is not.
And so then a notary could charge really anything he or she might want to charge for anything outside of protesting a negotiable instrument.
Well, there's no fee cap. The Secretary, of course, has said that the charge must be reasonable, but that wouldn't make Massachusetts unusual. If you look at JA Volume 3, page 15, there's a chart there of states and their handling of notarial acts and price regulation of them. And there are a number of states that say notaries may set their own fees. And I will also point out that chart lists Massachusetts among them. My brother said that the whole world has always viewed these notary statutes his way, but that's not correct. The expert notary bodies, people whose job it is to study these regulations, say that fees are not regulated in Massachusetts for any notarial act beyond protest or noting a protest. And those documents can be found at volume of the appendix, page 14, page 6, page 88. They predate and postdate the 2017 amendment.
Sorry, could you repeat? It is kind of crackly. Can you just repeat where you would find that in the appendix?
Yes, it's volume 3.
Yep.
They're page 6, page 14, and page 88.
And where's the chart that you mentioned?
The chart is on page 15, also in volume 3.
Thank you.
Justice Safer.
I have no questions. Thank you.
Justice Kafker.
Before you start, are you on a speakerphone? Because you're very hard to hear, and I can hear everyone else clearly.
I'm not on a speakerphone. I apologize for that. I will try to speak up.
Yeah. So I guess back to settled expectations. Was Romney's executive order, did that unsettle expectations? I'm trying to understand, what the world was before that executive order. Was it exactly the same? What did it mean?
I think the world, in the relevant sense here, was exactly the same. And you don't have to take my word for it. The executive order itself says that. It says it didn't alter or amend existing law. So it took the fee caps that had long existed in Section 41, and it reminded the public and it reminded notaries that they are mandatory, but didn't alter their scope. It didn't change Massachusetts law. And then if you fast forward to 2016, 2017, when the legislature amended the statute, it simply codified that executive order. Again, the executive order was said it did not intend to alter or amend existing law. If the legislature in 2017 had wanted to impose a $1.25 fee cap on all notarial acts, it easily could have done that with a one-line provision saying the fee for all notarial acts is $1.25. Notarial act is a defined term in Section 1 of the new statute. That section actually lists a number of notarial acts. They're not interchangeable, as my brother suggests. They all have different requirements. The legislature could have easily provided this fee cap if it had wanted to. It would have provided fair notice for this now criminally enforceable provision, but it did not do so.
So could you give me some examples? I understand the one that costs 25 cents. I understand what costs $2. What are the ones that are give me some descriptions of common notarial acts that are only subject to the reasonable fee requirement.
Sure, Your Honor. So if you look at in our statutory addendum, we reproduce Massachusetts Code section chapter 222, number 1, definitions, and it lists acknowledgments, affirmations, a whole bunch of notarial acts, and it also defines the notarial act as any act that a notary public is empowered to perform. The last one on the list is signature witnessing. This is at page 72 of our addendum, and that's that kind of common thing that we think of as notarizing, where you go in and you sign a document and the notary stamp on it. That's a defined term in the statute, and that's what Mr. Richardson, the plaintiff in the underlying case here, obtained. And so Massachusetts has not chosen to regulate the price for all of those provisions. It left in place the Section 41, which regulated the price only for what were very important services in the century. And the provision was adopted in the 1830s. $1.25 was actually a lot of money at that point. But there's no indication here. Yes, please go ahead.
So all these signature witnessings are just subject to reasonable market prices.
Yes, Your Honor, as a number of other states have done. But of course, I would point to the facts of this case aren't particularly relevant, but to the extent that the charges that are reflected in the record here show that we're talking about a $10 fee, or when you include the fee for the notarization and service fees. So we're not talking about exorbitant amounts of money.
Right. Okay, that's all I have. Thank you.
Chief Justice Gantz, let's assume for the sake of this argument that your argument in your brief is correct, that in 1836 the term noting was a quite defined term and was referring to the particular acts of protest, which are largely archaic now. So assume you're right. You distinguish that there's a difference between a notarial act, which is broad, and as you note, is also defined in Section 1 of 222 as any act that a notary public is empowered to perform. Still stuck, frankly, on Section 19, because that says a notary public shall perform a notarial act for any person requesting such act who tenders the fee provided for in Section 41 of Chapter 262 or any other general or special law or executive order. So why does that not mean that in 2016 the legislature essentially said, well, the price in Section 41 is the price which a notary public must accept for any notarial act, even if the definition of noting was more limited back in 1836?
Because, Mr. Chief Justice, there is not just one fee in Section 41. There are 6 different fees. So that reading of the statute, which I understand my brother has advanced, doesn't hold up, because one would have to look at Section 41, turn the page to Section 41 to see what the fees that are, quote, provided in. That's the phrase that's used in Section 19. And when you look at the fees provided in Section 41, there are a whole bunch of them. There's one for protest, there's one for recording, there's one for noting, there are separate fees for notices, then there are 2 aggregate fee caps for the whole cost of protest and the whole cost of noting. And so the legislature, this would have been an incredibly awkward way for the legislature to take one piece of that statute that has 6 different fee caps, somehow broadly enforceable, even in the context of a statute which itself adopted a definition for notarial acts, not noting. That's not the way that the legislature would have gone about it. And Justice Scalia famously said legislatures don't hide elephants in mouthholes, and I think this would have been, an elephant of broad, wide-ranging price regulation in a mouthhole of this obscure cross-reference that isn't the way the legislature would have done it. And it's certainly not a way of doing it that would provide adequate notice to notaries.
So what does it mean?
It means that the provisions of Section 41 are mandatory. And
but those, in 2016, nobody does those archaic acts anymore. So,
well, respectfully,
why would they
do? Respectfully.
I mean, of the percentage of notarial acts that are done, what fraction would you say fall within the historic scope of Section 41?
I don't have an empirical answer to that question. I know that protest still does happen and is required to happen under the UCC for foreign negotiable instruments, but I will concede that they are not major services provided by notaries today. I think at most what Section 41 could reflect is a misunderstanding of the scope of Section 41. But a legislative misunderstanding is kind of an unexpressed assumption isn't how the law changes. The law changes through amendment. And we've cited the Peters versus Machin case from this court, which involved construction of a statutory term in a way that rendered superfluous a separate statutory exception. And what the court said was that exception was actually unnecessary because the legislature misunderstood the scope of the definition. Here, too, I think at most these provisions may reflect an unstated and unexplained assumption about the scope of Section 41, but they didn't alter it, they didn't amend it, and that's what they needed to do if they wanted to give it the wide scope that my brother called for.
But let's assume you're right. Let's assume, you basically say a whole lot of people misunderstood because they didn't recognize that noting was a particular term of art. But let's assume you're right. If everybody basically assumed that noting was as broad as your brother said, and that it ultimately has come to mean, or albeit perhaps mistakenly, that $1.25 is the price for all notarial acts, why can't the legislature basically adopt that misunderstanding and say, well, that's what we now intend to do?
Well, I think if they had amended the statute, they could have done that. If they had reenacted the statute, perhaps there would be a ratification argument, but they didn't do that either. They left it in place. And in fact, they were expressly codifying an executive order which said it was not intended to alter or amend pre-existing law. And I, again, would just respectfully question the premise that everyone viewed it that way. The expert notary resources, the kinds that a notary would consult when trying in good faith to comply with the law, all said that fees were not regulated in Massachusetts. So those who understand these terms and understand regulation of prices for notaries all came to the same conclusion, and I'm not aware of any resource or notary guide that my brother has cited to the contrary.
So your view is that even with Section 19 in place, if I go to a notary and say, here's my $1.25, and please notarize my signature, so I guess the term of art is signature witnessing, that notary can say, sorry, Gantz, $1.25 isn't going to do it. I want $10 and I refuse to do it for $1.25.
Yes, Your Honor, because the $1.25 provision comes from, of course, the end of Section 41, and really every rule of statutory construction would lead to that same conclusion. If that notary looked at Section 41, and knew something about statutory construction, the notary would apply, for instance, the rule of consistent usage. It would see that noting at the end of the sentence, there's a very strong assumption that it would mean the same thing as noting earlier in the very same sentence, which is noting the non-acceptance or non-payment of a negotiable instrument. There's another statutory canon, which is that general terms take meaning from context, and it's undisputed that the whole provision up until those last 20 words is about protest, and that's reinforced by the fact that it says noting, including reporting. There's no notices for witnessing a signature. That makes sense only in the protest. You have the omission of settled terms that I still haven't heard anything for the proposition that noting means all notarial acts. That notarial act is itself a defined term. And then we have the rule against superfluity. A bunch of other charges in 41, the charge for protest is higher. So if this is a cross-cutting catch-all fee cap, it renders the fee cap just before irrelevant. So I mean, I think you could teach a class in legislation on this case because it's so many different rules of statutory construction, including the rule of lenity, come into play, but they all point into the same direction, that noting is a term of office that is only in this context relevant to protest of a negotiable instrument.
Okay, I've got no further questions. Any other justice have any further questions? And hearing none, that concludes our argument in this case. I thank counsel both for their argument and for their briefing. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.